Where do you
You know, and
reside?
I wouldn't dare not come back to court. I wouldn't dare.
Really?
Yes, Your Honor.
So if you don't come back, then I can just lock you up and don't have to hear from you again.
Yep, that's right.
I can do that?
Yes, sir.
Court does call the case of people versus Devontian or Devontian Gibson. I set up yesterday.
Not the senior assistant prosecuting attorney.
Step on me.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of Mr. Gibson. Your Honor, I tried to go and visit Mr. Gibson at the jail yesterday. Mr. Gibson was apparently in court on other matters.
Yes, he was here.
I heard. I spoke to his counsel on those matters, and I've spoken to the people. My understanding is they're working on a global resolution on all these issues. So if we could go out a couple weeks and see if we can get everything
Where
wrapped
did we
up.
put his other?
I'm gonna tell you.
I think we put his other case. I think we put his other cases to the first. I'll let you guys finish.
Yes.
To the first.
I'll ask him. May I address bond, Judge?
We tried that yesterday.
Just told him that.
Okay, well, let me adjourn this because we said his other matters for the first.
Thank you, Judge.
So probable cause conference in this will be May 2nd, 2024, 9 a.m. Okay, go ahead.
Thank you, Judge. My client indicates that he has a personal bond on his other files. He's asking you to make a personal bond on this file as well. He indicates he will come back to court. He's hoping to get all this wrapped up as a global resolution, and he's hoping you will consider a reduction on his bond.
Respond.
I want to compliment Mr. Feaster on the spring collection.
Oh. Thank you, Mr. Cannavy.
That's a sincere compliment. You are very familiar with this defendant. He has cases with your honor. I believe he also has one case with Judge Frushauer, which is an OWI case, if I'm correct. If the court's inclined to reduce the bond, I know the court will impose appropriate conditions on this defendant. But we're trying to work out a case resolution where all of the pending cases are resolved.
Okay. Where do you
You know, and I
reside?
wouldn't dare not come back to court. I wouldn't dare.
Really?
Yes, Your Honor.
So if you don't come back, then I can just lock you up and don't have to hear from you again.
Yep, that's right.
I can do that?
Yes, sir.
Wow.
That's how confident I am. I'll be done.
Yeah, that's it. Yeah. Okay.
Just so you're aware of the posture of our case, the felony case that you have today,
Yeah.
the offer that I made to Mr. Feaster involved reductions on these two felonies to misdemeanors in conjunction with pleas on the pending misdemeanor cases. So everything ultimately would be misdemeanors and they would be under likely your supervision. because you
Yeah.
have the lion's share of those cases.
Okay. Do you reside in Chelsea area?
No, Your Honor.
Where do you reside?
It's a matter.
Because I don't know. I don't have the other files, but I don't know if I have the current address because that's not the address I have on the. We have an empty address for the other cases. Okay. Or cause case people versus Alyssa Cox. Okay, what are we doing? It does have a plea form. The plea form indicates she's going to plead guilty to the charge of use of heroin, the 1-year offense upon her successful plea to that charge. Well, I got my numbers here. Is that a count 3? Right. I have 1, but then it says count. I got it. So where it says count 3 under the, got it. Okay. Well, so 2 corrections on the form then. Under offense, where it says it should be count 2, use of heroin, the 1 year. And then what would be dismissed would be just count 1.
Correct.
Correct.
Got it. So that she's going to plead guilty to an added count 2 of use of heroin, the 1-year offense. Upon her successful plea, count 1 would be dismissed. And there is no objection to 7411 on count 2 if otherwise eligible. That is court's full understanding of the agreement.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony about to give the truth, the whole truth, and nothing but the truth to help you God.
I do.
State your name.
Alyssa Cole.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of heroin. Is that correct? That is a misdemeanor that is punishable by up to 1 year incarceration and a $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
Understanding that, you still wish to plead guilty?
Yes, Your Honor.
I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, I understand.
All right. Still wish to plead guilty?
Yes.
All right. To that charge, how do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Did she sign any advice?
Yes.
Nope. It's okay. Yeah, you did it. It's just, ma'am, you realize that since you won't have a trial, you're giving up certain rights.
Yes, Your Honor.
You understand you're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you? You're doing this voluntarily
Yes, Your Honor.
of your own free will. And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of September 27th, 2022, 317 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan. Well, it's interesting. Okay, that's quite right. Did you have fentanyl in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
Did you know what you were using was fentanyl?
Not really. Yes, yes, I did. Like, you never know with that stuff, I guess. I did not know it was fentanyl, but I thought it was heroin.
I thought it was heroin.
Yes, sir.
All right. And the only reason I'm asking counsel is because the complaint was it looks like amended to fentanyl and heroin was struck.
I did not have, I apologize, I must have missed that. I didn't have that as the
Okay.
complaint, but I had heroin listed.
But you knew that it was one of those two.
Yes.
Because you don't know, right? And you used it.
Yes, sir.
All right, counsel.
That's fine.
All right, court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be,
12 at 10 a.m. before Judge
what'd you
Barr.
say?
June 12th at 10 a.m. before Judge Barr.
June 12th, 2024, what time?
10 a.m.
10 a.m. before Judge Barr. Bond will continue. All right,
Yeah.
thank you. Court calls case People versus David Crawford.
Good afternoon, Your Honor. Chris Easthope appearing on behalf and with David Crawford, who is present.
Good afternoon.
Your Honor, Ms. Town and I have been speaking of regarding the case.
How'd that go? No, just never mind. None of my business.
It was very productive.
What? I
It was very productive. Your Honor, we're asking, or I'm asking, if the court would, while we continue our very productive discussions, if we could move it out 30 days or around May 16th, the PCC, while we continue to discuss the matter.
All right. No objection. Probable cause conference will be, I can give you May 16th. Will that date work for you? That
Works
date?
for me, Your
All
Honor.
right. May 16th, 2024, 9 a.m. or as your invite indicates. Bond with its conditions will continue.
Thank you.
Thank you. Court calls case People versus Benjamin Crowell.
Good afternoon, Your Honor. William Amadeo, P7619, for behalf of Benjamin Kroll. I appear via Zoom. He's in person. Ben, please state your name for Judge Simpson.
Benjamin Kroll.
All right. I have before me a plea form. Is that what we're doing on this?
That's correct, Judge.
Yes, Your Honor, there should be a copy in your file.
Yes. The plea form indicates that the defendant would be pleading no contest to 2 charges, counts 2 and 3, count 2 being attempted possession of a loaded firearm in a motor vehicle, and count 3 brandishing a firearm in public. The count 2 is a 1-year offense count 3 is a 90-day offense. Upon a successful plea to no contest plea to those charges, count 1 would be dismissed. That's the court's entire understanding of the agreement. Is that correct, counsel?
That's correct, Your Honor, and the reason for the no contest is civil litigation.
Very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Benjamin Kroll.
All right. Sir, it is this court's understanding that you're going to be pleading no contest to 2 charges. Is that your understanding?
Yes,
The first charge is that of attempted possession of a loaded firearm in a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. It also requires mandatory forfeiture of the weapon or device. You understand that?
yes, sir.
It court also is also of the understanding that you're going to plead no contest to an added count 3 of brandishing a firearm in public. That is also a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and also mandatory forfeiture of the weapon or device. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Believe I do. After talking to.
All right. 2 things about a no contest plea I have to make sure that you understand is it first of all means that you're not further desirous or wanting to contest these 2 charges. You understand that?
Yes,
All right. Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
fortunately, yes.
Okay, you do understand that though, sir?
Yes.
All right. What I would be doing, and I have reviewed the police report, I would be taking those factual allegations as true to determine whether or not these offenses were committed. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. That you would be sentenced before Judge Balvo in the 15th District Court.
Okay.
Okay, you understand all of that?
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead no contest? And if you don't, if you're unsure and you want to speak to your attorney, sir, I'm watching you and I'm a little bit.
I'm just nervous. That's all. Sorry.
No, it's okay. I get that you're nervous, but one of the things I have to make sure, and part of my job is to make sure and be convinced that you understand everything that you're doing. You follow me there?
Yes, sir.
And I want to make sure that you do. And so I will go to whatever extremes I have to try to make sure that you understand and know what you're doing.
Okay.
If you want me to, and I'm not, and trust me, I'm not going to be angry about it. I'm not going to be upset about it. Neither will your attorney or anybody else. If you want me to adjourn this out to another date so you can get your questions fully answered by Mr. Amadeo or his staff, I can do that if that's what you want me to do.
I've talked.
Judge, could I briefly
Hold
talk to my
on,
client?
Mr. Amadeo. Hold on.
Yes, sir.
Is that, you want me to just do, here's what I'm going to do.
Yeah.
Okay, because I've got to make sure. And I'm not convinced that I think you understand something. I think you may have some questions that may also be leading to your nervousness. So I'm going to make the decision because part of my job, I'm not going to take your plea today. Okay. What I'm going to do is I'm going to pass it. There'll be no penalty to you. Okay. So don't even think that. All right. I'm going to put it out to another date. You'll be able to get in contact with Mr. Amadeo in his office and just answer any questions that you might have. Okay. And I think I'd feel better about that. And I think that you might also.
Okay.
All right. 2 weeks. 2 weeks. Will that work, Mr. Amadeo, for you? May 2nd?
Let me just check my docket, Judge. That'll be fine, Your Honor. Thank you.
Court calls case People versus Jessica Huffman.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Huffman. Ms. Huffman, will you please state your name for the record?
Jessica Huffman.
All right. I have before me a plea form that indicates that she is pleading to 2 charges. First, the stated count two of operating while intoxicated. And then an added count three of use of a controlled substance, that being fentanyl. The 1 year offense. Upon her successful guilty plea to those charges, count one would be dismissed. That's the court's entire understanding of the agreement.
That is correct, Your Honor.
That's correct.
Can I have her sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
State your name.
Jessica Huffman.
All right. Huffman, it's this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that correct?
Yes.
All right. The first is the stated count 2 of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. Court could also order your vehicle immobilized. The court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes.
It's also this court's understanding you're going to plead guilty to an added count 3 of use of a controlled substance, that being fentanyl. That's a misdemeanor punishable by up to 1 year, $2,000 fine plus court cost. You understand that?
Yes.
All right. Oh, these are mine. All right. Understanding all of that, you still wish to plead guilty to the charge of operating while intoxicated? How do you plead?
Guilty.
To the charge of use of fentanyl, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of these offenses?
Yes.
On the date of July 22nd, 2023, at the location of Washtenaw Avenue near Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was. Yes.
Prior to operating that motor vehicle, had you ingested a combination of controlled substances?
I was under the impression it was heroin, but later
Pardon?
found out that it was fentanyl. So
Okay, but you had somehow or another put that into your system?
yes.
All right, and you said that was heroin, what you thought was heroin, but it was fentanyl?
Yes. Correct.
All right. Were you stopped by the police?
I had fell asleep at the wheel, and I'm assuming somebody called the police and woke up to them.
Okay, and so the police
driving
were,
the search vehicle.
so after the police arrived, were you ultimately arrested?
Yes. They sent me to the hospital, did blood tests, and arrested me.
Okay, and the blood test revealed either, well, marijuana was in your system, is that correct also?
Yeah.
And also fentanyl?
Yes.
Or its derivative? You don't have any reason to dispute those blood test results, do you?
No.
All right. And you do, and as you've indicated, you thought you were using heroin, it turned out to be fentanyl, but in either event, you knew what you were using.
Correct.
All right. I think that's it. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is
Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation as well as screening and assessment are ordered at the 14A1 District Court. Sentencing in this matter will be May 22nd, 2024, 9 a.m. That is before me. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you. She could probably stop right down on her way out. Off to probation. Calls the case of the people versus Deanna Johnson.
The senior assistant prosecutor.
And Assistant Public Defender Dave Bellinger on behalf of Diana Johnson, who appears by my right. Can you please state your name for the record?
Diana Johnson.
All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of use of methamphetamine, the 1 year offense. Upon her successful guilty plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
That is our understanding as well, Your Honor.
Right.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So, yeah.
State your name.
Diana Marie Johnson.
Ma'am, it is this court's understanding that you're going to plead guilty to the added count 2 of the use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court cost. Is that your understanding?
Yes, it is.
All right. I do have to advise you that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, I do.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty. Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, I understand that.
You signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay. Yeah. Yes.
You understand you're giving up your right to appeal of right.
Pardon?
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will and because you believe that you're guilty of this offense?
Yes.
All right. On the date of April 21st, 2022, at the location of 704 South Main Street, City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Had you used it?
No.
Were you
I'm sorry, Your Honor.
were you intending upon using it?
Yes. Yes.
All right. And you knew what you intended upon using was going to be methamphetamine?
Yes.
All right. Considering that she's now pled to the higher charge, counsel, have I
Yes, Your Honor.
complied with the court rule? with the
Yes.
proper
Yes, Your Honor.
People satisfied.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
16th at 1:30 before Judge Valvo.
May 16th, 2024, 1:30 before Judge Valvo.
Thank you.
Bond continued. Thank you. You'll never make it down that hallway. Court calls the case of People versus, is it Pierre Jordan?
And good afternoon, Your Honor. Andrew Meyer on behalf of Pierre Jordan. Mr. Jordan, could you state your name for the record?
Pierre Jordan.
Your Honor, this is the time and date set for a probable cause conference. I have discussed the matter with Mr. Jordan. We are asking the court to set this for the next available preliminary exam.
Discovery is all complete.
To my knowledge, Your Honor.
People have their witnesses available the 30th. Preliminary examination in person will be set April 30th, 2024, 9 a.m. That is before Judge Barr. Bond will continue. Thank you. Calls the case of the People versus Michelle Cabo Flesh Blessing.
Andrew Chilvers appearing on behalf of the people.
Bridget Coons on behalf of Ms. Kaplafesh Blessing. I can't state your name for the record.
Michelle Calflesh Blessing.
Your Honor, I'd just be asking for a short adjournment. There was a plea offer on the table. I haven't had a chance to review it in full, and I'd like that opportunity.
Just the one where she needed to be arraigned on two.
Does need to be arraigned, yes.
All right. Counsel, you are aware of the added charges
Yes,
of the possession of methamphetamine, ecstasy, the 10-year felony, and operating while intoxicated, the 93-day misdemeanor.
yes, Your Honor.
As to the arraignment on those, how does your?
So I believe it should be a felony drunk driving.
Oh, it is. I'm sorry. You're correct. And it's actually the operating while intoxicated third offense.
Yes, we would waive formal reading and stand mute.
It's been, court will accept that. Well, defendant having waived formal reading and standing mute, court will enter not guilty plea.
Oh, you know what?
You're asking that this be adjourned over with all three charges.
Yes.
Probable cause conference in this case will be adjourned May 9th, 2024 9 a.m. Bond will continue.
Thank you.
Well, hold on a second. What was the it was a controlled substance. She's testing, so we're good. All right.
Thank you.
Thank you. All right, fine. Court calls the case, People versus Lakita Johnson.
Good afternoon, Your Honor. Amy Rise on behalf of the people.
Good afternoon again, Your Honor. Andrew Meyer on behalf of Lakita Johnson. Ms. Johnson, could you state your name for the record? Thank you. All right. Your Honor, this is a time and date set for a probable cause conference. First of all, we appreciate the court passing this matter so Ms. Johnson could be here. We are asked twice.
Okay, go ahead.
Yes. We are asking for an adjournment here because Ms. Johnson is considering a plea offer that's been extended by the state. She just needs a little more time to consider it, and I think we were just negotiating some of the finer points. So I would be asking for a 2-week adjournment.
And that is all accurate.
All right. And you have talked to your client about her progress report.
We have discussed that. I do understand the court's concerns. First of all, I did remind Ms. Johnson that it is important that she continue to test every time her color or number is called. Secondly, I will be providing Ms. Johnson with information regarding obtaining a medical marijuana card. She likely would be eligible based on it. I'm no expert, but I'm imagining she'll be able to obtain one in short order.
Yeah, like who can't? I'm sorry. Probable cause conference will be adjourned May 9th, 2024, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
All right, thank you.
I think that's the version from the signed in the complaint.
Court does call the case, People versus Brenda Brown.
Tina Sachs on behalf of Ms. Brown, who's standing on my right. Ms. Brown, state your name for the court, please. Brenda Brown.
All right, what are we doing?
Yeah.
I start off by saying the council and I have been, I'm prepared to offer a misdemeanor, false pretense. It's a 1-year misdemeanor. It's my understanding that the defendant has restitution money to pay. So if the court's inclined for an adjournment, allow the defendant in the interim to pay that restitution money to the clerk's office. We come back for the next PCC date. I'll have a plea form ready. We can enter a plea at that time.
And how much is the
$1,225.22.
Say again?
$1,222.25.
You know, it's the same amount. Sorry, it's the same amount on the complaint. It's listed on count 1 amount, $1,025.
Got it. Thank you. $1,225. I'll indicate that the defendant may post that amount as bond to be held for restitution. And then I'll adjourn this over to the May 2nd, 2024, 9 a.m. as your invite indicates, and her bond will continue. Ma'am, the funds will have to be posted at the 14B District Court. So that's the underlying jurisdiction. Okay. Court calls the case, People versus Willie Morgan.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Yes, good afternoon, Your Honor. May it please the court, Delphia Burt appearing on behalf of and with Mr. Morgan by Zoom. My P number is 47688. Mr. Morgan, would you state your name for the record, please?
Willie Morgan.
Thank you. All right, what are we doing today?
Your Honor, I did not have an opportunity to confer back with Ms. Barroso. She did send me an email yesterday evening. I relayed that email to Mr. Morgan, and I guess she could state on the record as to whether or not she intends to still offer the 1-for-1, 1 felonious assault plea, 1 dismissed, and that will be under HIDA. Is that an offer?
That was what I communicated to you yesterday evening. Nothing has changed since then. So
Okay.
yes, but we
Okay.
can't, he would need to waive up to circuit court in order to accomplish that.
Right, we've already discussed that. So, Mr. Morgan, is that how you wish to proceed, having heard it on the record now?
Yes, ma'am.
Okay, so Judge, he has
Okay.
been advised of his right to a preliminary examination. He understands the twofold burden of the prosecutor in terms of establishing a crime was committed within the city of Ypsilanti, and that he is probably the person that committed that offense after being so advised as his choice to waive his right to an exam understanding he'll be
All
bound over
right.
to circuit court for further proceedings, and he's ready to respond to the waiver.
All right. Is that a correct statement, sir?
Yes, Your Honor.
You understand the hearing called a preliminary examination. You will not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their right.
Yes, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Counsel, as to the circuit court arraignment, you waive reading. Your client stands mute at this time.
Yes, Your Honor.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
May 23rd at 1:30 before Judge Slate Thursday.
May 23rd, 2024, 1:30 before Judge Slay Thursday.
Okay, thank you. Have a great day. Thank you, Mr.
Right.
Morgan.
You do the same. Bond
Okay,
will
take care,
continue.
Judge.
Court calls the case of the people versus Emily, is it Benzina?
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Good afternoon, Your Honor. Jason Sakis appearing on behalf of the defendant by Zoom, who is also on the Zoom that I can see, Your Honor.
Ma'am, could you state your name?
Good morning. I'm Emily Vesna.
Okay. All right. What are we doing?
Well, Judge, because my client is in a hospital right now, my preference would be to adjourn the probable cause conference. I haven't spoken to the prosecutor yet, but I have received the discovery. If the prosecutor is inclined to have some discussion, which I hate to do this way, Your Honor, then we could adjourn that probable cause conference. If not, my client's prepared to waive the preliminary examination and have it bound over. So I haven't had an opportunity yet to sit down with my client to discuss the discovery because she's in the hospital, Your Honor.
All right. So she's in the hospital. So this becomes a timing issue.
If she hasn't had a chance to go over the discovery, I would not feel comfortable with waiving.
Well, that's not going to happen anyway. So I'm going to give you the time to be able to get to your client, counsel. That's not a problem. So we'll do that. Do we have a time frame? I realize she's in the hospital, and is she going to be out soon where she can meet with you, or you can get there? I mean, just tell me what you need.
Yeah, Judge, my understanding is, I didn't want to step on your words there. My understanding is that she's going to be released from the hospital tomorrow. And whether it is tomorrow or not, I know it'll be soon, and then I'll be able to meet with her in person. If not,
all right.
Well, that's what my understanding is, Judge.
All right, here's what we'll do. I'll adjourn the probable cause conference to May 9th, 2024. 9 a.m. or as your invite indicates. And then that way you'll have time. You guys aren't rushed, and you can get back and forth to the prosecutor, see what can be worked out, if anything. Okay?
Appreciate that, Judge.
Fair enough?
Thank you, Your Honor.
All right. You're welcome, ma'am. The bond will continue, and please be well.
Thank you.
Emily, I'll see you later, and thank you, Oscar, as well. Sorry, Judge, that I made that comment, but I haven't been able to talk to her much. Have a great day, everyone. See you soon, Emily.
All right.
Bye-bye now.
Take care. Court does call the case of people versus Paris Sherrod.
Good afternoon, Your Honor. Deborah Geraldine Bledsoe Ford on behalf of Paris Sherrod.
Good afternoon.
My name is Paris Sherrod.
There you go. Okay, thank you. All right, what are we doing?
I have talked to the people and told them that we intend to hold the exam. She has seen her discovery, and I've talked to her about her version of the events and her version of the events after we went over the discovery. I think she's correct in wanting to hold the preliminary exam.
Okay. So the discovery is complete, and would the people have their witnesses available on the 30th? All right.
Just for the record, her parent, since I have a younger child, I mean, I call her a child.
Okay.
But her parents are here, and
Where are they?
My father,
her father,
Oh, okay.
my sister.
her father and her sister.
Okay.
here.
Father and sister.
I always go to court with all them, and I just appreciate when I'm acknowledged, and my nieces and stepsons. So,
Well, no, I appreciate when they're here, because it shows they're not in the world alone.
That's right.
That's the most
Makes a big
important thing
difference.
sometimes,
That's right.
whether they've done right or not.
That's right.
It's
Well,
okay. So what I will do is I'll set preliminary examination in this matter to be in person, April 30th. Would you be available, counsel?
Yes.
All right, April 30th, 2024, 9 a.m. That will be before Judge Fresh Hour.
Okay, thank you. That's in this building, right?
That's in this building. And actually, it's Judge Fresh Hour, so she'll be in courtroom B. Court does call the case, People versus Christian Philippe.
And good morning, Your Honor. Rita White on behalf of, please say your name for the record, Mr. Phillip.
Morning, Christian Philippe. And it's morning in Australia, so we're good. All right. Good afternoon.
Good afternoon, Your Honor. My
All right.
apologies.
It's all
It's been a long morning for me.
All right, what are we doing?
Your Honor, I have made a plea offer in this case and communicated that with Ms. White. I'm not sure how she was received.
Yes, Your Honor. I did receive a plea offer on February 16th in the evening, and I didn't want to interrupt Mr. Phillips' nighttime, so I provided him the offer yesterday. And given the time frame of the offer of assault and battery and 1 count of disorderly conduct, he needs to think about it. I understand there's been several adjournments, but I don't want to rush. Several, yes. So I am asking politely for an adjournment.
Any objection from the people? Press conference, May 2nd.
Okay, thank you.
Go ahead. Here on the second. I like my colleagues a lot, so maybe go.
The 9th.
Thank you.
May 9th, 2024.
Okay.
9 a.m. or as your invite indicates. Bond continued. Court does call the case of People versus Benny Lee DeNovi. Go ahead, Madam Attorney General. Here, please.
Good afternoon, Judge Carrie Angie, appearing on behalf of the Attorney General's office.
All right.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Genovi. Mr. Genovi, will you please state your name for the record?
Benny Genovi.
This is a waiver.
It is, Your Honor.
All right. Sir, it's this court's understanding you're waiving your right to have a preliminary examination?
Correct.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive the right.
We do, Judge. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on single count.
Your Honor, we would acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set for
May 29th at 1:30 before Judge Conlon.
May 29, 2024, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond
Thank you, Your
will
Honor.
continue. Thank you. Court calls the case People versus Lakita Johnson.
Good afternoon, Your Honor. Andrew Meyer on behalf of Lakita Johnson. Ms. Johnson, if you're present, please come forward. Your Honor,
go ahead.
I'm going to ask the court to pass this. I was just texting with Ms. Johnson. She is en route to the courthouse when about 2 minutes ago, she told me she was 8 minutes away. So I think we can address this today if the court would be so gracious to pass it.
Gracious. What is that? You think I am? Fine. I'll pass it.
Thank you, Your Honor.
Case People versus Nicholas Clements.
Good afternoon again, Your Honor. Andrew Meyer on behalf of Nicholas Clements. Mr. Clements, could you state your name for the record?
Nicholas Clements.
Thank you, sir. Your Honor, this is the time and date that for a probable cause conference. I have discussed the matter with Mr. Clements. He is asking me set this for the next available preliminary exam date.
Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 30th. Preliminary examination in person will be set April 30th, 2024, 9 a.m. before Judge Fresh Hour. Sorry.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Christopher McDade.
Image Canatra, Senior Assistant Prosecuting Attorney for the People.
Your Honor.
Upstairs. Good afternoon.
And if you could just state your name for the record. Christopher Michael McDade.
All right.
And Your Honor, we were just gonna be asking for a 2 to 3 week adjournment today. We still have some discovery to review, and also it was, I was informed by Mr. Ganatra that they are reviewing some pending potential charges against my client, so we want to see about keeping those together.
Probable cause conference, May 9th, 2024, 9 a.m. Bond continued. Okay.
All right.
Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Thank you, sir. Calls case, People versus Lakita Johnson.
Andrew Meyer on behalf of Lakita Johnson.
It's been 8 minutes.
I understand that. It's a fast 8 minutes.
My clock.
Your Honor, I'm asking for one more active grace report, which I know is an awful lot. But could we pass this?
Whoa, it's an awful lot for somebody like you. Is that what he was saying?
No.
That's what I heard.
Grace.
I heard, no, that's what, didn't he say that? Yes, he did. Fine. That's okay. No, go ahead and insult me. All right. I'll pass it.
Thank you.
Call it up in the next block.
Thank you, Your Honor.